Hello, this is Attorney Brian Pendergraft with the Pendergraft firm, and the topic for today's video is: can I be evicted by my wife, husband, boyfriend, girlfriend, or spouse or domestic partner in Maryland? All right, let's get into it. So, can you be evicted by your wife, husband, boyfriend, girlfriend, spouse, domestic partner, etc.? So, I think the best answer is it depends. If you're on the deed with your partner as a co-owner, then as a general rule, they are not allowed to evict you or lock you out. On the other hand, if you're not named as a co-owner on the deed, then as a general rule, they are allowed to evict you or lock you out, but they must first go through the legal process in order to obtain a court order. In most counties in Maryland, this process takes a few months. But what if you have a legal court order that allows you to stay on the property? Then you can stay on the property. An example of this is you are granted temporary use and possession of the property during a divorce. Even if your name is not on the deed, then you can still stay. But what if you paid for 100% of the house and you and your wife agreed that just her name would be on the deed? Well, then, too bad. They can still ask you to leave. So you may be entitled to equity in the property. A judge may even determine that you may be entitled to most of the value of the property during divorce. That said, you're not entitled to live in it, and your outsized contribution doesn't matter. But what if we have a written agreement that I can stay on the property even though I'm not on the deed? Well, then most likely you can stay on the property per the terms of the agreement. So you have to look to the terms of the license or to the lease agreement to see what conditions you may be asked to leave the property. And if the agreement wasn't in writing, then there's a strong chance that it may not be enforceable due to the statute of frauds. But what if we have children together? Can my partner still evict me? Yes. Without a court order authorizing your use and possession of the property, your partner can ask you to leave if you are not on the deed, even if you have kids together. So my spouse or ex-partner keeps attempting to lock me out or evict me without a court order. What are my options? I think it may be time to consider getting a protective order from the district court or perhaps a use and possession order from a civil action such as a divorce. Can I evict or lock out my husband or wife to prevent domestic violence? Maybe. So you have to do what you have to do in order to ensure your safety. And it is reasonable to protect yourself by locking out your aggressors. That said, I think I'm right to assume that the burden of proof will be on you to show that it was reasonable to lock them out. So immediately contact an organization that helps victims of domestic violence and let them know your situation for guidance. Call the police and consider filing a protective order against your partner. Does my spouse or partner have to give me a notice to vacate before evicting or locking me out? I think at a minimum, an informal notice is required. So even if you're wrongfully in possession of the premises, many judges at least want to see that the violating party was asked to leave by the owner. A formal notice may be required if the parties have or conducted themselves in a way that could be perceived as a landlord-tenant relationship. For example, if you pay rent, then you may be entitled to receive a formal notice to vacate. Thanks for watching. I hope you enjoyed this presentation, and I hope that you do not find yourself in this situation. However, if you are, then my contact information is on the screen. You can see how to reach me. Again, my name is Brian Pendergraft with the Pendergraft firm, and thanks for watching. Take care.